Hello everyone and welcome to this session of Law for All. In today's session, we talk about cinematograph films and copyright in cinematograph films. Most of us love watching movies. When you go watch a movie, what is it that you observe? Is it the performance of the actor? Or is it the nature of the character? Or is it the plotline or the storyline? There are so many elements which come together to make a cinematograph film. The term cinematograph film is defined by the act to mean a work of visual recording and includes a sound recording accompanying such visual recording, and cinematograph shall be construed as including any work produced by any process analogous to cinematography, including video films. What this means is that the definition of the word cinematograph film in the Copyright Act is wide enough to including both commercial ventures as well as home videos. Commercial ventures could be feature films, short films, documentaries, animated movies, TV commercials, and so on. What we see as an audience of the movie is the end product, the film that gets made. However, the process of making this film is a long one. It is usually divided into 5 stages. The first stage is the development stage. This is the stage where the idea or the concept is developed into a tangible expression which can be protected by copyright. This could be either in the form of a storyline or a script. Thereafter comes the pre-production stage. In the pre-production stage, the crew is decided upon, the set design happens, the set locations are decided, the actors are cast, and every such thing is done which will ensure the smooth running of the next stage, which is the production stage. In the production stage, the actual shooting of the film happens. In the fourth stage, which is a very important stage, is the post-production stage. It is in this stage that the footage which is created at the production stage is worked upon, edited, the music is added, visual effects are added, and a final product of what we see as a movie is actually created at this stage. The fifth stage is the stage where the work is communicated to the public. This usually happens either through cinema halls or in recent times through OTT platforms. This is known as the distribution stage. There are various people who are involved throughout in these processes in the making of the film. A cinematograph film can incorporate various other categories of works in it. It could be a literary work, a script, lyrics, or dialogues in a movie. It could be a musical work, which is the graphical notation of the harmony or melody of the background or theme music or a song in a movie. The sound recording is the actual recording with the lyrics, with the sound of the singer in the actual song or the musical theme of that movie. There can also be a dramatic work, which would be either the choreography or some dance movement in that movie. Artistic work, which could be incorporated in a movie, could be either a painting or a sculpture or the costume design or the set design. All these works come together and are incorporated in the cinematograph film. As the producer of a cinematograph film, in order to enjoy copyright in the cinematograph film, it is important that the producer has the right to use these works and incorporate them in the cinematograph film. If the work, which is known as the underlying work, these works which are created, these works which are incorporated in the film are known as underlying works. If the producer has commissioned the creation of these underlying works, then the producer is the first owner of the copyright under the Copyright Act. If the underlying work is created by an employee of the producer, then again the producer is the first owner of the copyright in the underlying work. However, if the producer is not the first owner or the author of this underlying work, it is important that the producer gets a license or an assignment to incorporate and use these works in the cinematograph film in order to ensure that the film itself does not infringe upon any of these underlying works. While there are many people who contribute creatively to the making of the film, according to the Copyright Act, it is the producer who is the author of the complete cinematograph film. How long is the right that the producer has in the cinematograph film? How long does he enjoy it for? The right of the producer in the cinematograph film is for a period of 60 years from the date of its publication. After 60 years, the work falls into public domain and can be freely used. A word of caution though, although the producer's right in that film may have extinguished, the right of the authors of individual underlying works in that film may still subsist, and it is always advisable to check and get licenses from these authors if you intend to use that work. What right does the owner of the cinematograph film have? We know that the producer is the first owner of the cinematograph film. The producer has a right to store the film, to make copies of it earlier on films or video cassettes, and now on CDs, DVDs, and other mediums. He also has the right to communicate it to the public. Remember one thing, copyright is a negative right, which means that the producer has the sole right to do these things in exclusion of the others. And if at all another person tries to use that work or to make something out of that work without the permission of the producer, then the producer has a right to seek damages or seek an injunction against that person for infringement. In order to determine whether a subsequent work is an infringement of an earlier work or not, the courts in India have laid down certain tests and certain principles. One of the most important judgments on this aspect is the judgment of the Supreme Court in R.G. Anand versus Deluxe Films. This was a case where it was the plaintiff's plea that the defendant's film, New Delhi, was an infringement of the plaintiff's play, Hum Hindustani. The court, while considering this aspect, has laid down certain principles. Let us look at them. The first principle that the court laid down was that there exists no copyright in an idea, subject matter, theme, plot, or historical or legendary facts. The second important principle is that where a same idea is being developed in different manner by different people, there are bound to be certain similarities in it. What needs to be seen then is whether the similarities are fundamental or substantial aspects of the mode of expression adopted in the copyrighted work. The third principle is, it's an important principle, and that is a test to determine whether there is actually a violation of the copyright in the earlier work. And this test says that what is necessary to be seen is whether a spectator or a viewer who has seen both the works, the earlier work as well as the subsequent work, after watching the subsequent work, whether he comes to a conclusion that the subsequent work is a copy of the earlier work. The principles laid down in R.G. Anand are followed till date. The second judgment that we will look at is the judgment of the Bombay High Court in Zee Telefilms versus Sundial Communication. This was a case where the plaintiff had developed a certain storyline. They had shot a pilot of a TV series. The defendant's TV series, and it was the plaintiff's claim, infringed upon the plot line and the concept notes of the TV series developed by the plaintiff. The court held that there were such striking similarities between the defendant's TV series, which was titled Kanhaiya, and the plaintiff's TV series, which was also titled Kanhaiya or Krish Kanhaiya, and that the latter work was in fact an infringement of the earlier work. The third judgment to consider, and this brings out a certain variance or contradiction which exists between the view of the Bombay High Court on this point and the subsequent view of the Calcutta and the Delhi High Court. In Star India versus Leo Burnett, the Bombay High Court has taken a view that for a subsequent work to be termed as an infringement of a prior work, the subsequent work has to be a mere reproduction or a physical copy of the earlier work. This is a very narrow interpretation. In Star India, the court was concerned with the plea of the plaintiff that the defendant's advertisement, which consisted of similar setting of almost identical characters, was an infringement of the plaintiff's TV series and the plaintiff's copyright in the characters that the plaintiff had created. The Calcutta High Court and Delhi High Court have disagreed with his views. In MRF versus Metro Tires, the Delhi High Court was concerned with the plea of the plaintiff that the advertisement made by the defendant, here both the plaintiff as well as the defendant were involved in the same kind of business. They were both manufacturing and selling tires. The defendant's advertisement, the plaintiff alleged, was an infringement of the plaintiff's advertisement for tires. The Delhi High Court, while considering this plea, came to a conclusion that the view taken by Leo Burnett, the Delhi High Court disagreed with that view, and the court said that for a work to be termed as infringement of an earlier work, what needs to be seen is whether the foundation, the substance, the kernel of the earlier work is reproduced in the second or the subsequent work. The court also approved the tests which were laid down in R.G. Anand's case to be applied where two cinematograph films are compared. While holding this, the court stressed upon the need for a purposive interpretation of the Copyright Act in accordance with India's obligations under the Berne Convention in order to ensure that the interpretation of the Act is in consonance with the meaning given in the Berne Convention. These are some of the factors that courts in India will look at in order to determine whether a subsequent work is an infringing copy or not. The first of these is access. This means that the court will see whether the creator of the subsequent work at all had access to the earlier work. The second of these tests is the substantial similarity test, where the court sees what are the similarities within the two works and what are the dissimilarities within the two works and whether they can be said to be substantial in nature or not. In order to see the similarity, the court often uses the observer test, where the court sees whether an audience or the spectator who has seen both the works will come to an unmistakable conclusion that the second work is a copy of the earlier work. These are the defenses which are available for a defendant in a suit for infringement of copyright in a cinematograph film. The first of these defenses is a defense under Section 52 of fair dealing. Section 52 lays down certain circumstances in which a work in which copyright subsists can be used by any person without seeking any authorization or license from the owner of that copyright. What are these circumstances? Some examples could be for personal use, for criticism, for review, for reporting of current affairs. These are some of the circumstances which are laid down by the Act itself. The second of these defenses is the defense based on the doctrine of scene affair. Scene affair means that these are such common scenes which are common in that particular genre that there is no originality in them. This doctrine was laid down in Kane versus Universal Pictures. There was a scene in the movie which was about a couple getting into a church and taking shelter in a church during a storm. The court said that this is such a common scene and there is no originality as such in that scene, and therefore such scenes cannot claim protection. The third defense is the defense of de minimis. This really means the doctrine of de minimis translates into the court shall not take notice of trifles. What it means is that there is a violation of the copyright of the owner in that work. However, the violation is so small, so trivial that the court will not take notice of it, considering the damage or the harm which is caused to the plaintiff in that matter. Some of the circumstances which the court has laid down. This is the judgment of the Delhi High Court in India TV versus Yashraj Films, where the court considered the applicability of the doctrine of de minimis and laid down certain factors which the court will consider while applying that doctrine. The most important of it is to gauge what kind of harm is caused to the plaintiff by the defendant's use of that work, and what is the intention of the defendant in using of that work. This was a case where the defendant had used 3 seconds from a very popular Bollywood Hindi movie, a song, 3 seconds of the song from that Hindi movie in an advertisement. This was an incidental use, and the court held that the defendant was protected by the doctrine of de minimis. There was violation of the copyright, but there was no infringement of the copyright. Access to advanced technology and rise in the use of digital content sharing platforms like TikTok or YouTube or Instagram or Facebook means that we are creating and sharing more content than ever before. This makes it challenging to protect the rights of owners in cinematograph films. The courts are finding novel ways of doing this by issuing John Doe injunctions, which is injunctions against unknown persons, or dynamic injunctions in order to curtail digital piracy and illegal sharing of copyrighted works. It will be interesting to see how all these developments bring about a change in the law with respect to ownership of copyright in cinematograph films and with respect to protecting this copyright in the cinematograph films. Thank you.